record, my name is Mary Soliday. I'm attorney with 2700 Market Tower. I'm representing a number of citizens. Matter of fact, over 1,000 people have signed a petition in support of this matter today, loosely labeled the Guys Billboard Appeal Committee. I would like anyone here who supports our position that this sign was incorrectly permitted, that the permit was issued in error, to please stand up. Thank you. Members of the board, this permit for a board that is shown in your packet was issued on December 18th. It's a tri-vision billboard. The property in question, as I'm sure you know, is at the northeast corner of 79th and Fall Creek Road. We're putting up on the easel pictures of the sign in question. Members of the board, frankly, when this sign went up, I can't tell you the amount of disbelief that area residents and elected officials had that the city would permit this sign. In essence, we believe not only is it objectionable aesthetically, but we also think it's unsafe, and we think that's a rationale for you to revoke the permit. We also think there are some arguments under the ordinance, and we'll get to in a few minutes, that the ordinance was improperly interpreted by staff. Members of the board, regardless of what you hear from the billboard permit holder, you have the authority to decide whether this permit was lawfully issued or not. You have that authority under local ordinance and their Indiana code, so this is your decision. Members of the board, also, before we get into more of our technical arguments, want to point out not only do we have all these fine people who've taken their time to be here today, we have letters of support from State Senator James Merritt. We have the mayor of Lawrence, which is across the street, is the corporate boundaries of Lawrence, opposes, and Councilor Jeannie Kane has been kind enough to join us today. She intends to speak, which will not be counted against our time, as I understand it, based on your practice. Okay, what I'm going to call the reasons you have to lawfully revoke this permit? What are they? Well, the first one relates to, and this is set out in your packet, members of the board, tab 4, sign regulations. Section 734-100 states that the purpose of the regulations is to eliminate potential hazards to motorists. Section 2.02 prohibits signs which interfere with or obstruct the view of or can be confused with any official traffic signal or device. The Tri-Vision's own marketing material says that the board is impactful and attracts even more attention to a message. As you know, this intersection is very busy. There are many signs, there are multiple lanes. It's a little bit of a confusing intersection, to say the least. And I don't think there's any factual disagreement that there is a conflict, particularly when you look at the pictures in our packet, again, tab 4, that this sign interferes with the visibility of a traffic signal. So therefore, again, under the sign regulations, section 734-100, this permit should have been denied. Members of the board, there is also, I believe, a very strong legal argument that the measurement was improperly conducted, with all good intention, but improperly conducted by staff. That is because when you look at the history of this area and how other permits were issued, they were all based off the center line of Fall Creek Road, not the western right-of-way. And that relates to the original 1995 rezoning of the subject site. It relates to the zoning of the Oak Haven and Ridgewood Hill subdivisions, which again, when those permits were issued, were based off the center line of Fall Creek Road. And more significantly, under Municipal Code Section 730-101, the measurement is required to be from the center line. In this case, the measurement was done by staff based on the western edge of right-of-way. Why does that matter? Well, it matters because the zoning ordinance is clear. There has to be a 300-foot separation between a protected district, which is a residential district by definition, and the sign itself. So we have, in essence, based on this proper measurement, the sign is 20 feet in violation of that setback, meaning that it's 20 feet too close. And I'm not sure that it can be moved to make it in a proper place, based on this interpretation of the ordinance, which again is supported by municipal code. Thirdly, there have been a number of cases, at least two, and probably others, that have been heavily negotiated between neighbors, neighborhood associations, staff, and petitioners, going back as far back as 1982, when the C3 district was zoned, that required a, quote, uniform architectural styling and character with uniform signage. And I say this because I believe it's been the MDC and hence BZA established policy as to this property that a billboard, certainly, I don't think anybody could without being a little bit off base, say that a billboard that looks like this is of uniform architectural styling and character with uniform signage. The signage that's in the area with the CVS and the other small shops, small mom and pop businesses are uniform in character, and this really doesn't meet that commitment. You also have CVS, which in 2005 was able to, essentially through a long series of negotiations, negotiate with the neighborhood association and staff a electronic variable message center sign, which interestingly was never erected, which I think speaks volumes to the fact that CVS, on whose land this is located, thinks that even an EVMS sign is inappropriate. But regardless, at that time, 2005, CVS decided they wanted one. Long series of negotiations and commitments that basically said that, again, this concept that signage has to be uniform, it has to be in keeping with the character of the area, and clearly, again, that's not the case. So, in essence, we think that this is an interpretive question for you members of the board to decide. You have the authority to decide this. So with having said then sort of what I'm going to call legal arguments, we think there's also a number of policy arguments. I'm going to turn it over to Randy Frisk, who has led this group and has some comments and some handouts for your attention. So thank you.
Good afternoon, ladies and gentlemen. My name is Randy Frisk. I'm an 18-year resident of this area, along with my constituents who you saw here. We're talking about this sign. And much like the Colts lore sneaking out of the dead of night, this thing popped up all of a sudden, and everybody said, how did that happen? How upset were they? Well, in a short period of time, over 1,000 residents signed a petition to support this petition to revoke this permit. That included over 280 comments, with comments such as a jarring contradiction to the environment, dangerous to drivers. I can see it from my window. It cheapens the look of the area. And CVS, note that it's less than 60 feet, you can't see it on this picture, but less than 60 feet from this sign, logged a record number of complaints, according to conversations with their customer care line. In addition to that, as Ms. Holliday noted, we have Lawrence Mayor Dean Jessup and Senator Jim Merritt that have opposed this as well. So basically, what's wrong with this sign, in addition to what you just heard? It's a huge off-site advertising billboard that is completely out of sync with the surrounding, otherwise charming and well-manicured neighborhood shops and stores. And secondly, it's a danger to traffic in this area, specifically the eastbound lane of 82nd Street. Now, this property was originally rezoned C3. If you look at tab A of the documents you just got, this area was originally rezoned in 1982 to be a C3 property to provide services to and for the benefit of the residents, not a sign owner. And the images found in that tab show what the area is supposed to look like. Locally owned mom and pop shops, rolling hills, rural landscape, and winding streets. And this billboard destroys that aesthetic. Now if you look at the next poster here, you should have this, I think in tab 1 of the original packet that you got. You'll see the top section again, what it's supposed to look like with tasteful structure and grass, and then the middle one with the billboard. So what are we going to see in the years coming when property values drop? And mind you, there is a correlation between billboards and economically depressed property values. That's in tab C of what you've been given. So what's to happen in the future? Likely the bottom one, which maybe you can't see too well there, but in the packet you have gun shops, dilapidated buildings, lowering property values, and significantly a lowering tax base. The sign regulations of Indianapolis and Marion County in Chapter 734 recites the purpose of sign regulations to include encouraging signs which are integrated with and harmonious to the buildings and sites they occupy, to retain current residents, and to safeguard and enhance property values. Well, this sign not only does not do any of those, but it is 180 degrees opposite that. Also important, only 5 other billboards have been approved in the last 10 years for C3 properties. And you have that at tab 4 of the packet handed to you. What's significant there is that the other 5 are on intensely commercial corridors: Meridian Street, Raceway Road, North Michigan, Pendleton Pike, and South Emerson. You can see those are completely different in stark contrast to the current site at 79th and Fall Creek. But perhaps more important and more of a concern to the residents is that in each of those, for as far as the eye can see, you can see the billboard, it's flat. Also, the roads there are straight, and they don't have a curve dumping into an intersection, which has been labeled substandard by a 2011 scoping report, which is tab D in your packet, which found that stretch of 82nd Street to be substandard, having a 14.5-degree grade and a horizontal curve and a 40-mile-an-hour approaching speed limit. So, what are we talking about here? This is extremely important. When you're coming down 82nd Street toward Fall Creek, the top picture, you see the surrounding foliage, the trees. Then you come down, all of a sudden you're in an intersection. What do you see? You see this billboard, this huge billboard that has tri-vision with panels that rotate. And the advertising for that on tab 4 of your original packet says that that is specifically to better attract the attention of people looking at it. So you're down there, you're coming down the intersection, all of a sudden your attention is grabbed, and all of a sudden you find yourself in the middle of this intersection. So the question I ask is, how many cars with a child seat in the back need to be T-boned from the side with somebody with right-of-way because they were distracted by this sign? Thank you.
Near the billboard intersection for 25 years. And I have a relative who lived in the area for 70 years in a hill overlooking this intersection, and we all cherish the beautiful nature of the valley. And just as my family and I have had our lives enriched by this beautiful area, I want current and future generations to have the same privilege. Here are some comments that fellow residents have made about the billboard. A sign of this size belongs in an area like Castleton, with mostly business traffic. Most of the heavy traffic at this intersection is residential. There are 2 small strip malls near the billboard. The billboard detracts from signage of local businesses in both of these strip malls. We need to support our local businesses and not make it harder for people to find them. A realtor posted this comment: "I know the billboard will not bode well upon those looking to purchase homes in the area. The billboard makes the area feel like a shady area." Another petitioner wrote, "While driving east on 82nd Street, I have caught my eye glancing at the billboard versus paying attention to the stopped cars or the stoplights in front of me." And finally, this intersection is the main route to high school for many local neighborhoods. High school students are less experienced drivers, and for everyone's safety, we do not need to have them glancing up at a turning billboard. This petitioner wrote, "I feel like my life is at risk now every time I head through that intersection." Thank you.
Thank you. This time is short. Let me just try to summarize, which is, first of all, my view is that Indiana code clearly supports the notion that your most important responsibility as a board is to protect public safety. I think you've heard a lot of testimony about grave concerns about that. Secondly, we understand, I know your counsel will tell you, that you are required to find findings of fact, 4 findings of fact that we're handing out now, that to support your decision today, should you choose to do so, and we hope so, to revoke this permit. So we have drafted those findings of fact, we'll show them to your legal counsel, but essentially, they touch on the things that I'm going to say one more time, which that first of all, I'm out of time, so I'll say that time for rebuttal. Thank you very much.
Thank you. We're going to hear from the
Well,
board.
Councilor Ginny Kane, I'm sorry. We have two city councilors.
I think you come out the remonstrator, according to my instructions. Okay, we'll hear from the remonstrator. You have 15 minutes. Remonstrator. Is that staff?
Chairperson Pat, members of the board, I'm Mike Quinn, attorney with offices at 320 Quinn Street here in Indianapolis.
Mr. Quinn, did I swear you in?
Yes, you did.
Okay.
The only reason I'm hesitant to come up here because I'm not really remonstrating, because I'm here as counsel for Mr. Lee, the permittee of the sign. Coincidentally, I've lived on Geist Reservoir for over 30 years, 32 plus years. That being said, my client informed me about a week ago that he and Mr. Frick had a conversation. Mr. Frick had informed him the case today would be continued, and so I'm not prepared to make a presentation since I was informed by Ms. Saladay, counsel for the petitioner or petitioners, that the case was going forward today. I didn't want to ask for continuance. I immediately called my client, and he said he could not be here and for me to go ahead and represent him as best I could. That said, and Mr. Smoker will certainly represent the city's stance on this particular petition, I would like to say on behalf of my client that my client has done everything that we're aware of that he needed to do to obtain the permit, and he did not tell any lies or mistruths or misstatements, if you will, in terms of obtaining this permit. Driving through that intersection every day, because I go through that intersection going to my office, which is here in downtown Indianapolis, and my home, I go through that intersection at least twice a day, sometimes 4 to 6 times a day. I didn't even know the sign was there until Mr. Lee called about 2 weeks after the sign was up. So it shows you how good I am, and I apologize to everyone here. And I happen to have been the misfortune of being the attorney both on the rezoning of the southwest corner of 79th and Fall Creek, as well as the Kroger store, and as well as the EVNS sign that Mrs. Saladay referred to. That being said, I would defer to Mr. Smoker in any questions he may have. Again, I am not prepared to make a presentation on behalf of Mr. Lee, and I would like the board to know that. Thank you.
So I guess we'll hear from Mr. Smoker. This is just for the audience to know, we don't usually have cases like this. This is an unusual one for us, and so I guess I need to know whether the city is limited to, in our remonstrance, our 15 minutes. Is Mr. Smoker under that 15 minutes?
No, he's not.
So you're not, so we will go straight to council. We're done with remonstrance, we'll go to council, and then have staff. This is really new for me, who is who in this room. Yeah. So, yes, so let's hear from the city council.
Thank you very much. Good afternoon. My name is Jenny Kane, and I'm the City County Council for District 5, where this billboard is located. This is the second time in 10.5 years that I have spoken to the Board of Zoning Appeals on a subject in my district. That is how important this appeal is to me and my constituents. What is important to us? Number one, the setting. I have been known to tell people who cannot make it to Brown County in the fall to go drive Fall Creek or Sargent Road for the same effect. The hilly terrain, woods, Fall Creek Valley, Mud Creek, The animals you will see, the natural settings are all gems to enjoy and preserve. The uniqueness of this area has been recognized in the comprehensive plan for Indianapolis. The comprehensive plan labeled the area around the billboard a critical area because of the Fall Creek Valley, woods, a heron rookery, protected well fields, and hilly terrain. Therefore, a huge tri-vision billboard does not fit the aesthetics and natural beauty of this area for the people who live there, drive there, and have contributed to the comprehensive plan. Secondly, when going east on 82nd Street to Fall Creek, there is a winding hill going down into the intersection of Fall Creek and 82nd. When you get to the bottom of the hill, the stoplight falls directly in the middle of this billboard that is changing for the driver's sightline. It is very distracting, and I believe this is a safety hazard for this already tricky intersection. Third, I have watched scores of my neighbors from my district react to this billboard. What can we do? Well, what we can do is what we're doing today, this appeal. I have watched them email me and city officials. They have set up a Facebook to communicate to each other. Over 100 people came to our first town hall meeting on this. Money was raised for the appeal in less than 3 minutes. They formed a committee that has met weekly to research and organize. We've gotten over 1,000 signatures for the petition. Hundreds of flyers have been passed out, and money has been raised for legal representation. The commitment of time, talent, and money by these many neighbors to stand up against this particular billboard because of the reasons I have stated is very admirable to me. I am so proud of each one of them, and I hope you see that this is important to all of us. We want to protect and preserve the natural beauty of this unique area of Marion County that we call home. Thank you for your consideration. I also want to mention that City County Councilor Michael McQuillan has written a letter that can go into your record. And I'd also like to invite Councilor Steve Talley, who's come today, to also speak on this. Thank you.
Thank you very much, Madam Chairwoman and members of the commission. I'm the councilor for District 11, located just immediately west of the sign referenced in this petition. As council members elected to represent the citizens of Indianapolis, we have a responsibility to provide a safe and healthy environment to raise and educate our children. And a major component of meeting that responsibility is by encouraging home ownership and standing firm against business attempting to encroach into residential areas. And this billboard, and a billboard such as this one near the entryway into a residential community, does in reality constitute a business encroachment and does not encourage home ownership. It is my belief this business encroachment into a residential neighborhood can have a negative impact on property values. And as councilors that represent the neighborhood with a shared boundary, I ask that this commission consider the interests and the comments that you've heard today from our Lawrence Township residents, and thank you for your consideration.
Thank you. Are there any questions? So we will now vote on 2014 AP 100.
2014 AP 1001, 4 votes cast. Ellington voted yes. Clark voted yes. Hatch voted yes. Taft voted yes. 4 yes.